Joining us to talk about the decision that came down yesterday for the Flathead Warming Center, we have Christie Hebert. Good morning, Christie.
Good morning, John. How are you?
We're good. Robin Mitchell is with me here. So,
Hi, Christie. Hi, Christie.
How come it took almost 2 weeks for us to get this decision from Judge Christensen?
Sure. It looks like the judge paid, really careful attention to what was going on and reviewed all the evidence. The judge wrote an opinion that was 42 pages, and over half of that opinion was a facts section with citations to our complaint and to evidence in the record. So I think that's why it took so long, to be honest. He was being careful.
And is there a chance that this could be appealed?
Yeah, a preliminary injunction decision like this can be immediately appealed. And so I think that for sure was motivating the judge's decision here, trying to make the decision as bulletproof as possible.
Is it bulletproof in your legal opinion?
Nothing is bulletproof in my opinion, right? Even bulletproof glass isn't quite bulletproof, but I would say it's a great opinion, and he focused on the facts of what happened in detail and really refuted the city's story by a piece of evidence after evidence. And that makes it more likely to stand up on appeal. Appellate courts don't usually scrutinize or overturn a lower court's version of the facts.
So talk with us a little bit about, first of all, set the table for us on all of this and what the judge decided and what's likely to happen next.
Sure. So the judge granted a preliminary injunction, which means that the judge is saying the city's revocation of the warming center's permit can't be enforced. And that means that we go back to September 15th, 2024, when the warming center had its permit, and it can open its doors just like the revocation never happened. And that preliminary injunction will, unless there's some intermediate decision by an appellate court, will stay in effect until there is a final judgment. So the warming center will be able to operate just like it was operating in prior years for the foreseeable future until there is a final decision, in this case, on the merits. That's what this means.
So talk with us a little bit about the merits here that you're talking about.
Sure. So the merits, is a following a full trial before the court. And what happens next in the case is discovery. Basically, the parties exchange all their information, the emails, they take depositions, they provide any documents they have that, can be looked at by the other side. We call this as like a poker game where all the cards get placed face up on the table. So that's what happens next. And with a more fulsome collection of the evidence, the idea is that there is another trial further down the line.
Any idea when this trial will begin?
No, I don't know exactly, and it depends on the court schedule. And so usually what happens next is the court will enter some kind of scheduling order saying, here's how long you have to do discovery. Then if you want to file any motions after that, here's when those are due. And this is our timeline for when a trial will be held. And all of those things take time. But the decision that yesterday was saying that the warming center could open while all these things happen. And in fact, the warming center did open last night. It provided shelter for over 30 individuals just last night.
I want to kind of just make sure everybody understands what is going on here in terms of the complaint itself and your response to that complaint.
Sure. So the complaint is what the warming center filed and drafted. And that complaint is 106 pages and lays out exactly, with evidence, citations throughout it, what happened. And the court, in this opinion, really found that what the warming center was saying happened had a lot of validity, and that there were serious questions, serious problems with what the city did, And if the warming center didn't open, there was likely to be what's called irreparable harm, something so bad that it wouldn't be necessarily be able to be fixed by money later. And the city argued that, the public interest would be better served if the warming center remained closed. And the judge said, no, that's not true. If anything, keeping the warming center closed was likely to increase the problems and hardships seen by the public rather than solve them. So that's pretty telling. And also the court rejected any idea that Tanya Horn, the executive director of the warming center, lied. In fact, the mayor himself, the judge pointed to the mayor's testimony himself that there really was no evidence that Tanya had lied, and the mayor kind of tried to indicate that there was a misrepresentation of some sort in the application, and the judge in the hearing kind of laughed at that, like, there's a difference between a lie and a misrepresentation. And the judge in his order basically said that wasn't, he didn't see any evidence of that right now, and that the city's criteria for revoking the permit was speculative, nebulous, and wholly baseless for revoking the permit. So I think that is an extremely strong indicator of where this case is going.
So, all right, in that regard now, what kind of scrutiny is going to be placed on the warming center?
Yeah, well, I mean, right now there's not a particular scrutiny that is placed on the warming center, but they're committed to, maintaining their commitment to being a good neighbor. We're looking at ways that we might be able to address community concerns with the city. And our next steps are going to be to reach out to the city to continue the conversation, even though there is a preliminary injunction and the warming center can operate as it was doing. Those are our next steps.
How long is this likely to take? If once we get this thing to trial, how long are you prepared to be in a courtroom?
Yeah, so I don't know how long the actual trial will go. We had a whole entire day-long proceeding when it was just the preliminary injunction. I would imagine that trial would take at least a day or two, maybe 3 days, depending on what the evidence shows, right? But I don't know what Judge Christensen's court calendar is. I have seen that he does have a fair number of criminal matters, and those always have to take priority. I would imagine that we will have a couple of months of discovery, and then, depending on the court's calendar, we would try to go to trial. But it's not going to happen in the immediate future. I would imagine it's not going to happen until at least late 2025, if not 2026.
So the preliminary injunction is going to stand pat for quite a while.
That's right. That's exactly right. And even if there was the warming center happened to lose at trial, which I think is very unlikely, but even if they did, we would ask that the preliminary injunction stay in effect pending any appeal.
I'm really wondering here, and I want to come back to something, and maybe I misphrased it, but during this period of time when the preliminary injunction is enforced, what kind of scrutiny is going to be placed on the warming center to see that they're abiding by whatever rules there are?
Well, I'm not really sure what you're asking me there, John, but the warming center has always been committed to being a good neighbor. They have an occupancy agreement which requires their guests to do certain things, and if their guests don't do those things, the warming center excludes them. That's really the only mechanism that the warming center has for enforcing certain behaviors among the homeless population. But the warming center has and continues to try to pick up trash around their property and around the immediately surrounding properties. They try to be responsive to complaints and at least engage in conversation with those complaints. So the warming center is continuing to do what it can with its property and in the community. But quite frankly, it's not responsible for patrolling the entire community or controlling the homeless population. And even the judge, in his own opinion, highlighted how the mayor was unable to draw a line about where the warming center should be, quote unquote, policing or taking action. So there's not really affirmative requirements for the warming center to do anything in the broader community. But the warming center is committed to being the best neighbor it possibly can, and will continue to live out that commitment.
We're talking with Christie Hebert, an attorney for the Institute for Justice. If we could just take a moment, Christie, and talk about the Institute of Justice and your work there. Why did you step into this fray?
Sure. So the Institute for Justice is a national nonprofit law firm that advocates for and protects for constitutional rights across the country. So we bring lawsuits across the nation to protect constitutional rights. And one of the areas that we focus on is property rights. And in this case, the warming center had a property right in its conditional use permit that the city took away without providing due process and took away in an arbitrary fashion. So that's why we got involved here. And that's part of our broader commitment to checking the use of zoning power in a way that really undermines people's ability to use their property in a constructive way. And cities like Kalispell all too often use that zoning power to keep out people and businesses they don't like in an arbitrary and discriminatory fashion. So that's why we got involved in this particular case. The warming center was a particularly egregious example of a municipal government abusing its power to strip a property right.
So property rights are kind of the direction that your firm takes. Those are the kinds of cases you're looking for?
Sure. We take a lot of property rights cases. We have a big, we're well known for eminent domain and targeting eminent domain abuses. We also have a First Amendment practice, a robust First Amendment practice. We work on government immunity and accountability, addressing those issues and why government officials need to be accountable for their actions. And we also have educational choice pillars. So we have four main pillars: property rights, educational choice, free speech, and economic liberty. And then we have a couple of additional projects. But that's what we focus on.
We have a local law firm that's representing the city outside of the city's legal department. Have you had conversations with them since this preliminary judgment was issued?
No, we haven't had any conversations with them since the preliminary injunction was issued, but I expect that we will be speaking with them in the next week. We had several conversations with them, obviously, before the hearing, and I'm hopeful that we can continue to work together.
Any chance for a settlement?
I don't think there's a particular chance for a settlement here unless the city is willing to recognize what it did was wrong and publicly own up to that fact and institute changes to ensure that that kind of thing never happens again. Otherwise, we're moving fully forward to trial. Barring some exceptional circumstances, I think things will be moving forward.
Christie Hebert is our guest. She is an attorney for the Institute for Justice, representing the Warming Center. Christie, is there anything that you can tell us that I haven't brought up or asked about?
I think just this case highlights the importance of the right to use your property to shelter others, and that's particularly what's going on here. Not only had the city granted a permit that the warming center had a vested property right interest, it couldn't take away that right without providing the warming center a full and fair process. And one of the things that the judge really highlighted is, at least at this preliminary stage, it did not seem like the warming center got a fair process.
Christie Hebert, thank you so much. We appreciate the continuous communication we're getting on this. This is going to be a long process, I'm sure, and we'll follow it all the way.
Thank you, John. Take care.